Canada's leading law firms on Bay Street in Toronto. He was born and raised in Alberta, and Ibrahim holds a computing science degree from the University of Alberta and a law degree from the University of Toronto. Ibrahim is also a founder and director of a community of over 4,000 professionals in the Greater Toronto area. And last but certainly not least, we have Imam Nabil Khan from the Abu Bakr Islamic Center in Surrey, BC. Imam Nabil received his master's in Islamic Studies from Al Ihsan Institute, where he is now also a teacher. And Imam Nabil has studied the Islamic fiqh and principles of wills and estate planning. MashaAllah, today we have a panel of highly qualified and very knowledgeable presenters who will discuss the importance of estate planning in Islam and go over the legal aspects and requirements of testamentary documents such as wills, power of attorneys, and representation agreements. We will end the presentation with a Q&A session, and you can submit your question to the speakers at any time through the chat box. Questions will be answered at the end of the session, and if possible, please include which speaker your question is directed to. As a disclaimer from the CMLA and our speakers, nothing said or presented today should be taken as legal advice or representation expressed or implied in any way. Our speakers cannot give answers for specific fact scenarios. Our aim today is to inform you of the various legal options available for Sharia-compliant estate planning in the Western context. Thank you.
So it's great to be one of your presenters today. Thank you very much for that very kind introduction. So today we're going to be addressing various items. We're going to be talking about why estate planning is important. We're going to, of course, be discussing wills, powers of attorney, representation agreements, and questions. For many of you, when we started the session today, we put up a poll, and if you just give me a moment, I'm just going to share the results of that poll. And so you let us know whether you have a will. So many of you don't have a will yet. Some of you do, which is good. And some of you are hoping to put one in place before the end of the year. Powers of attorney, which we'll be explaining during today's presentation. Some of you have powers of attorney. And it's interesting to see that we sort of have a mix, lots of people from cloudy British Columbia and lots of people from Ontario as well. So welcome everyone, salam alaikum. Thank you for being here. The fact that you've taken the time on a Saturday afternoon to be here to learn about estate planning shows that you truly care about your family's welfare and you're planning ahead, which is a really big step. And we congratulate you for doing that. So why is it important to plan? It's important to plan during your life. You work hard, you arrange your affairs. When you're no longer here, you want your family to be looked after, whether that's your partner, your young children, or perhaps if you don't have a partner or you don't have children, the rest of your family. You want what you've earned, what you've saved during your life to go to the people you want. And so it's so important to plan. It's unfortunate, but almost 56% of Canadians do not have a will in place. I do know for those of you that don't have a will, you're going to be taking steps between now and the end of the year to put in place a will. And there are lots of ways to prepare wills. You can contact lawyers like myself or Ibrahim. Some people can go online. The important part isn't how you do it, it's the fact that you do it. Because like I said, just as you plan for while you're alive, it's important to plan for when you're no longer here. So if we go on, within the Muslim context, it is very important to have a will. And as you can see here, it's related from Abdullah ibn Umar that the Messenger of Allah has said, "It is not proper for a Muslim who has anything to bequeath to spend more than 2 nights without having written a will in his possession. And so we're not trying to stress you out. We're not saying you need to get it done right away, because 2 nights might be a bit quick. And I'm just gonna sort of see what happened to our PowerPoint. But having said that, please, you've taken the first step today, which is an important step, which is to be here to learn about preparing a will. Please now take the time to put in place a will. And we're just gonna arrange to get our presentation back on the screen. So we're going to be speaking today about 3 major areas and then some extra areas. We're going to be speaking about wills in British Columbia. I'm going to give a bit of an introduction in wills generally and a little bit about British Columbia. Then Ibrahim Danial will be talking about wills in Ontario. He'll continue to talk about Islamic wills as well as powers of attorney. And then I will touch on representation agreements, and then we'll take some questions at the end. If during our presentation you have questions, please feel free to put them in the chat, and then we can address them for you at the end. So when you're putting in, first, what is a will? A will is a document that sets out what happens to your estate. So that's your property, the things you've saved up during your life after you take your last breath. A will doesn't take effect until you take your last breath. And for a will to be accepted by the courts, it must have been signed by you in the presence of 2 witnesses. That's the major requirement. And so there are often cases where people will prepare a document and sign it and not take the next steps. In very few circumstances will that be accepted. And so if you're going to take the time to plan for the future, to plan for your family, make sure it's done correctly. In your will, you will set out what happens to your estate, what happens to what you've collected during your life. You can also leave gifts. So that would be doing charitable work. You might want to leave something for somebody outside of your immediate family, a brother, a sister, a relative, a charity, a hospital, a masjid, whatever that is, you can set that out in your will. And then for those of you that have young children, I often say, your money will hopefully make its way to your children. But what's more important is if you pass away, who's going to look after your young child or children? And I think if there's no other reason for those of you that are parents of young children who are on the call today, it's important to put in place a will so that when you pass, when you and your partner pass, it sets out who will look after your children. If you don't have a will setting out who looks after the children, then the issue is it your brother, your sister, your partner's brother, their sister? If you don't have brothers and sisters, who in the family? Your parents, your in-laws, who looks after your children? And in the meantime, until that's all figured out, the Ministry of Social Services gets involved and causes a lot of stress. Your family's already lost you. Now there's stress about who's going to look after your young children. So for those of you that are parents and have young children, if you've been putting off putting in place a will because you've been busy, and we're all busy, please take the time between now and the end of the year to put in place a will. So what does a will allow us to do? I've touched on it. So it lets us to choose who is going to receive our estate, that which we leave behind once we pass away. You can give specific items to specific people. So if you have something in your family, people often come and meet with me and say, I received, for example, a ring, a necklace, a piece of jewelry from my grandma, and I want it when I die to go to my sister or my brother. It will mean more to them than it will mean to my children. Then you can set that out in your will. You can also appoint, in the event that both you and your partner pass away, who then steps in to help manage your affairs. Is it a brother, a sister, a cousin, a professional, a best friend? You get to decide when you prepare a will. And then lastly, like I've said, most important in my mind, if you have young children, you get to determine guardians. Who looks after your children when you both pass away? So how do we help young adults preserve their inheritance? I have young children. My children won't inherit until they're adults. So if I were to pass tomorrow, between my passing and them becoming adults, what happens? Well, my will sets out at what age they will receive their inheritance. And from my passing until they receive their inheritance, it sets out what happens to the funds. So for example, if they need funds for a school trip, if they need funds to pay for university education, if they decide to study in Ontario like I did, and they need money for flights or for a laptop while they're in school, my and my wife's estate will pay for all of that. They won't get the money, and they'll even pay for their day-to-day needs. And then as they become adults, they would receive their inheritance. So you can set all of that out in your will. And then some people will determine that they don't want their children to receive all of the inheritance at 19 or 21. They might want to stagger it. So I have many people who say, I'm happy if my children, if my partner and I, if we were both to pass away before our children are adults, we're okay if our children receive some of it at age 19 or maybe at age 21, but we don't want them to receive all of it. So when you prepare a will, you can determine at what ages they will receive their inheritance, something, of course, very important. So what happens if you die without a will? Unfortunately, as I said, depending on the survey, over 50% of Canadians don't have a will in place. So in British Columbia, the government of British Columbia has come up with a plan. And the plan is if you pass away with a spouse and children, your spouse would receive the first $300,000 of the estate, and then the rest goes, depending on how many children you have, to the children. That might not be the way you want your estate divided. In fact, often that's probably not the most convenient. And if it's going to young children, now who manages it? If you don't have a will and automatically your estate has gone to young children, then in British Columbia, the Office of the Public Guardian and Trustee will come in to manage the funds. Do you really want to leave a government body to manage funds while your partner or your children are alive? You would probably want family to manage that. The government will take a fee for managing that. Your family won't. And so it's important to put in place a will so things happen the way you want them to happen, and the people you trust to manage your affairs can in fact manage them. So with that bit of introduction on wills, I'm going to pass it on to my colleague Ibrahim, who will be addressing wills in Ontario, and then he'll go on to address Islamic wills.
Assalamu alaikum. Everybody, you can hear me? Thank you, Azool. I'm going to talk about, as was mentioned, Ontario. And then we're going to get into how we actually practically do Islamic wills in Canada as a minority in a non-Muslim majority or non-Muslim personal law jurisdiction. So I'm not going to we have quite a few detailed slides. We're not going to go into like the minutiae, but we're going to touch on some of the key things. I'm just going to continue where Azool left off with respect to Ontario. So I just want to remind everybody that in Canada, you have items that are federal jurisdiction, some are provincial jurisdiction. Will law is provincial jurisdiction. And then you have two basic types of law in Canada. You have the civil law in Quebec, and you have the common law in the rest of the provinces. So Quebec is totally different. So if you live in Quebec, you need, we make sure you don't take everything here as the base. But for the rest of Canada, most of this is applicable. We have some minor differences between provinces. So for one example, as Azool mentioned, the $300,000 is the preferential share for the spouse to get if you don't have a will, plus the personal effects or household items. In Ontario, it's just a flat $200,000. In Alberta, when I last checked, it was $50,000. So these you have to know, but we want to avoid those situations about not having a will. Subsequently, if you have a spouse and children, your property is divided among the spouse and children in Ontario. If you have one child, after the preferential share, so after the first $200,000, it gets 50-50 between the spouse and the children. And if you have within the spouse and the one child, if you have more than one child, the first 1/3 over that $200,000 amount in Ontario goes to spouse, and the remainder is divided equally among the children. Or 2/3 is divided equally among the children. So basically, the larger estate you have, the more that's going to your children. So people just assume that everything goes to the spouse. Inheritance law is one of the exceptions. Also, with respect to common law spouses, you actually need, for Ontario purposes, to have a registered marriage that's recognized in Ontario. So you could be married in a foreign jurisdiction, but that marriage needs to have been recognized in Ontario. But you can't do just an Islamic nikah contract and have inheritance rights in Ontario. Just see if this works. The next screen, yes. There are also if you're not in the will, but you think you should be, there are things in Ontario called dependent support claim. And there's a similar process in BC, variation of wills, I believe. And that's probably even, in BC, it's probably the most extensive where judges and courts can change the will. But you shouldn't be relying on that, basically, because it's either at the judge's discretion, or there's one exception in most provinces where a legally married spouse can opt to ignore what he or she is receiving in the will and instead take 50%. So basically, they're deemed to have died before the testator, the person making the will. They get their 50% of the total assets of the deceased person. They cease to be executor. They cease to get any other share. It's as if they died before, as if they predeceased. So that is only entitled, or that is an option available only to legally married spouses, and you have to do it within 6 months in Ontario. A judge may extend that deadline, but it's at his or her discretion. Once again, we do not want to be in the situation where we have to rely on these kind of other things. It's much better if we plan in advance. Now, why we talk about testamentary freedom is because the British common law system allows testamentary freedom for the most part, which means you can do whatever you want with your money when you pass away in this society, subject to that spousal option that I mentioned earlier and the dependent relief claims. But basically, if you want to give all your money to a charity, to your cat, you can set up a trust, or you can do that. You know, I'm exaggerating a bit, but you basically can do that. Why does that matter for us? It allows us as Canadian Muslims to have that testamentary freedom to do Islamic wills if we want to do that. And that is kind of the crux of what many of us want to do. So now I'll just talk about Islamic will. Many of us know what a will is, and Azool described it well. An Islamic will is basically something that's according to Islamic law. And the key thing here is Islamic inheritance law is a clever and I'd say wise mix of a mandatory distributive system and a testamentary freedom system. So it has the best of the European systems where more like the shares are allocated, and the British system, which has the common law system, which means you have testamentary freedom. Now remember, this was 1400 years ago. And just as an aside, the more you get into Islamic inheritance law, the more you realize how clever and amazing it is. Now, we do have certain issues we have to deal with in a modern society and postmodern society, but the themes of distributing wealth so you don't monopolize wealth, where you avoid conflict. Lawyers, most of us, especially litigators, I'm teasing Azool a bit, we make a lot of money on human conflict. Now, it's better than gangsters shooting each other up. We have court systems where the judge does that for us, basically. But why go through all this? The whole point of Islamic law generally is, the point is to create justice, the point is to avoid inequity, and the point is to avoid unnecessary conflict. And so that goes straight to planning and straight to this balance. But also with this aspect of testamentary freedom, we're able to individualize our estate. Now, the 1/3 testamentary freedom portion in Islamic law, one caveat. In traditional Islamic law, you cannot give that to somebody who's already getting a pre-assigned chronic share, you could say. No, I touched on this a bit. Now, of course, the elephant in the room in the modern context is a woman getting half the share of a man within the same category and class. I'd like to clarify. So let me back up a little bit. From my understanding, Islamic law was the first legal system that gave a fully vested share to women, which means that once they received their share as their inheritance from their parent or their spouse or a sibling or a child, it was their full control. They had full rights to it. They could give it away, they could invest it, they could use it, they could whatever they want. And this was a haqq law, which means nobody could take it away from them. Now, practically speaking, in our patriarchal societies of our old countries and perhaps everywhere in the world, male relatives intervened as guardian roles to block this, but these could be overturned. And there's many Ottoman cases where women were deprived of their rights to their inheritance, and they intervened, and the Qadi gave them their right because this is a haqq Allah, a right given by God that nobody can take away. The other, so Islamic law, from my understanding, was the first to give a fully vested share to a woman. Jewish law had a life estate to widows, and daughters, from my understanding, did not inherit. Roman law had something a little bit for widows also. Now, to get to the half share, now I'm not saying what we should do now. I'll talk about what the options are from a practitioner perspective. But the other context is that in the ideal situation, as one scholar explained to me, a woman's share should be at her discretion in the sense that she can do whatever she wants with it. She should not be obligated to maintain herself from that wealth. It should be a bonus. He went on to say that perhaps if she has financial obligations, the share structure should be re-examined. Now, he wasn't giving a fatwa, and I can't reveal his name, but he's a prominent scholar in North America. But he said we need further exploration on this. So now I'm only a lawyer. I've worked with Islamic scholars. And as far as I know, there's no written fatwas on this, but there's a lot of spoken opinions that we've used over the years. I've touched on some of this, but I just want to go back to the cleverness aspect. So this is from Professor Rumsey from over 100 years ago, and he said, Mohammedan law of inheritance comprises beyond question the most refined and elaborate system of rules for the devolution of property that is known to the civilized world. So when I first began this journey about 12 years ago, Islamic inheritance law seemed very strange, I should admit. I felt that way at the time. But the more you get into it, the more cleverness and amazement I derived from it, at least. And if Rasulullah ﷺ had only spent his life inventing inheritance law, that itself would have been a full-time PhD and post-PhD job. And inshallah, perhaps we'll do future sessions on the intricacies of Islamic law, inheritance law, and have an Islamic scholar do that. I touched upon the fairness. I'll just continue in the interest of time. I mentioned that testamentary limitation, that only came about 30 years ago. And why I'd like to bring this up in particular is total testamentary freedom leads to injustice. So I believe the reason that their chronic shares are listed, as I mentioned, for distributive purposes, is that it's too much discretion. If you're able to give all your wealth to whomever you will, you may cause injustice to some of your children for no just cause, or to your spouse. So 30 years ago, most common law jurisdictions brought in this restriction on testamentary freedom because it was leading to injustice. And I would argue that's closer in principle to the Islamic inheritance system, where you have a mandatory heirs, but it's 2/3 and you have 1/3 individual freedom, which I think is an amazing balance, as I mentioned. Now, the whole problem is the tension that arises in our society. So our society in the West, in the so-called West, is based on the husband-wife unit, as perhaps it should be, because we're living in a nuclear family, extended family we've moved away generally from our extended family. It's not based on a traditional society where your clan and your family is what governs your life, and you're born and you die in the same village. So our society is based on the Islamic, or our society here is based on the nuclear family. So what does that mean practically? As you know, tax lawyers and accountants here will know better than me. Our society is based on spousal rollovers. So get an RSP spousal rollover to your spouse so that you don't get taxed as if that's income for the whole, for 1 year. So example, let's say you have $1 million in your RSP. In Canada, if you name your spouse as the beneficiary of that, he or she gets the $1 million, no income tax on that until surviving spouse, he or she passes away. However, if we are going to do the Islamic share strictly, you could get an immediate huge tax hit. So you have that $1 million, that could be taxed as $1 million income if you take it out. If you withdraw it from the RSP, you don't roll it over to the spouse, you get $1 million income tax hit. And as one scholar said, you know, we should not leave money on the table for the tax man to take foolishly, just to do a strict interpretation without using any hikmah or wisdom. So there's other capital gains exemptions on the principal residence, as you know. A whole bunch of joint, like, you know, other joint asset issues, joint tenancy laws, that there's no point. So let me back up. The whole point of Islamic law, as you know, Allah says in the Quran about why we were created, why the universe was created, and why Sharia was revealed to us. Of course, we're doing an interpretation of all of this, right? There's no like golden tablets that tell us all the interpretive methods we should use. We're using our best judgment, inshallah, with good intentions. And, you know, we ask Allah to guide us, that we're not misleading ourselves or anybody. And inshallah, that we hope to bring more justice to ourselves and our community and Canada. So we're doing our best. So we have to figure out why, you know, how do we reconcile the tension between, in Islamic law, the blood relatives are favored because that was how the clan and the traditional society governed itself, and could have trust, that you could trust those in your clan and in your blood family, and not so much on the spouse. But our society is different. I'll just continue. Okay. So I'm going to go hopefully to some practical options within Islamic law to solve this. So let me just do a normal example, and I'm sorry it's not in the slides, so please please try to follow the numbers. And so basically, say a husband, wife, and children and parents. So the mandatory heirs in Islamic law are spouse, parents, and children. So your husband, wife, your mother and father, and your children. So these almost always inherit. So how you do the Islamic process is the wife or husband gets the first share. It's called a fixed share. So he or she gets, it ranges between a half, a quarter, or an eighth, depending on if you have children. I won't get into the details, but you can see it's either maximum a half or down to an eighth. And then in certain cases, the father and mother get their share if they survive you, and then the majority, what's left over, goes to the children. So issues in our society, I'll get to the male-female issue, is how do we protect the key thing we want to do for our clients and as parents, as husbands and wives, is we want to make sure our spouse is not left destitute with the children, especially if they're young. So if we follow the strict Islamic distribution where the wife only gets 1/8 if you have children, and the husband only gets 1/4 if you have children, this may create issues, as Azool mentioned earlier. If you're giving assets to a minor, the public guardian trustee of the province can get involved. And even more importantly, is the spouse, the parent of those children, loses control over it. So how do we solve this? Within Islamic law, we can give assets while we're alive and healthy. So while you're alive and healthy, prior to being in a marid al-maut state, which is like a death sickness. So I would translate that as critically ill. We can give assets to our spouse while we're alive and healthy, under no duress. So this way, we can make sure our spouse is pre-gifted with certain assets. And then if you pass away, he or she inherits from the remaining portion, but has already been vested with some of the assets. Now, how we do this, whether it's formally or informally, depends on the context of our holdings, if we have corporate shares and so forth. Now, I would recommend people put their houses jointly with their spouse, but make sure that's your intention, that your intention is to pre-gift at least 50%. One scholar said in Oakville, Ontario, that we should give, it's reasonable Islamically to give 50% to your spouse, even if he or she did not work outside the home, so didn't formally earn the income, but was at home with the kids, for example. The other ways to do this is, if you have insurance, I'm not telling you to get life insurance, but if you have life insurance, it's a way to compensate your spouse who may be getting less from your formal inheritance. Maybe a way to compensate your daughters who are getting half the shares of the sons in the traditional perspective, and so forth. We can, I mentioned earlier about the RSP rollover. It's good to keep your named beneficiaries to your spouses in those assets where there's tax consequences to doing so, which are the RSP and the principal residence, which is a joint ownership or a named beneficiary. So what observant Muslim scholars in the GTA and North America have said is that we have to use our judgment. We can't have a computer program do this. We can't have an old template doing this. We need to assess the situation based on everybody's context, which is just really what, law is all about, ultimately. So I'm trying to go to the next slide. There we go. Okay. And did I skip one, Azool? Or that was? And the next one after that? Okay, great. So before I get to this one, this is just something I wanted to remind us since sadaqah as charity is which actually means truthfulness, as you know, is encouraged in our deen. I just want to give a quick example of an Islamic inheritance and talk a little bit more about the male-female ratio. So the male-female ratio is not always that the male gets twice the share of the female. So I just want to make that clear also. So in the normal case, say you're a 40-year-old couple, you have kids, and your parents are alive, inshallah. In that case, where you have children, the father and your father and your mother actually get the same. So your husband or wife gets 1/8 or 1/4 respectively. Your father gets 1/6, your mother gets 1/6, and your children get the rest, with the sons getting twice as much as the daughter in the traditional interpretation. So that's an example, and that's a common example where the male and female get the same amount in that distribution. And just to let you know, there was a minority of Sahaba who actually wanted to give the mother a greater share based on how they interpret the Quranic ayahs, basically. But that wasn't the majority of the Sahaba opinion. But it went so far as to that. And let me back up. So the inheritance law was overlaid on the Qurayshi legal system to give justice to women. And it shocked the Quraysh at the time. And they said, what, you're giving women's rights? You're giving rights to women? Next, you'll be giving rights to animals, which Rasulullah did also. So that's one example. A last example, which I think is really cool, where if a woman dies, leaving a husband, a father, and the daughter. So a woman dies, she leaves her husband, she leaves her father, and her daughter. So remember, this is 1400 years ago, but guess who would get the majority share? So how you do it is that you give the fixed share to the husband first. He gets a quarter. Then you give the next fixed share. There's no sons here, so the daughter gets a fixed share instead of the half ratio. She gets a half. And then the father gets what's left over, which is a quarter. So husband, father, daughter, wife just passed away. The daughter gets the biggest share, and nobody can take away that inheritance of her. So that is revolutionary, if you imagine that 1400 years ago. Unfortunately, a lot of our old countries, this is not, male guardian is blocking this, unfortunately. And unfortunately, women don't know their inheritance rights. Why this matters is in most Muslim countries, Muslim personal law, and in countries like India and I believe South Africa, Muslim personal law is still the default inheritance law. Okay. So inshallah, maybe we can address some of this more in questions. I'll just close with this, I believe. I just want to encourage in Canada, if you give a charitable donation in your final year or through your will, you can basically reduce your income tax to zero, basically in your final year income tax. So it's good to give sadaqah. Sadaqah means from the root word being truthful about your belief. Now, sadaqah during your lifetime is better, but on your will, on your death, is also good. But remember, this is capped at the 1/3 discretionary. A Sahaba wanted to give all his wealth to sadaqah, and the Prophet ﷺ capped that at 1/3. That also applies on your deathbed. At least Islamically, you can't start disenfranchising your heirs right before death. You should have done that while you're alive and healthy. Similar with the spousal gifts that I mentioned earlier. So the key thing is plan early. The last thing I want to touch on while you enjoy this cartoon is just for Ontario, Azool, I don't know if we have time later to talk about probate tax. It varies for BC, but it varies by province. Ontario has a significant probate tax of 1.5%, significant for the Canadian context. There's no federal estate taxes in Canada, but we have provincial estate administration taxes. Ontario is the highest at 1.5%. There's a way to defer this is by having your assets jointly held. That's just a deferral. Or if you have private corporate shares, so let's say you're a doctor or another professional person, you have $1 million in your professional corporation, or you're a business person and you have it in your general corporation, there's a way we can do a separate will called a non-probate will for those private corporate shares, and you can bypass basically the entire 1.5% tax. So basically, say on $1 million, you save 15,000. So I encourage if you have private corporate shares worth more than a few $100,000, you should like they own property or they have investment assets or the company's valuated at that, you should look into that. Azool, sorry to put you on the spot. What is the probate tax in BC? Sorry to put you on the spot.
1.4%.
Oh, okay. So it's similar. So these in Ontario, this was approved by the court. This tax avoidance scheme. It's not evasion because it's legal, but we should look into that. Azool, maybe I should pause and pause for now at least, and then maybe you continue, or should I continue?
Sure. So we want to talk about just 2 more documents quickly, and we've been getting lots of questions, so we want to answer your questions. That's an important part of today. There are 2 other documents you should be thinking about when planning for your estate. So we've talked about a will. We've talked about wills in British Columbia, Ontario, Islamic wills. The other document is a power of attorney. That is a separate document from a will. What that allows someone to step into your shoes. If you're thinking, why do they have shoes here? It allows somebody to step into your shoes to assist you with your finances before you take your last breath. So as you get older, if you're hospitalized for any reason and you need somebody to manage your accounts, to pay your bills, to assist you with your finances, it would make sense to put in place a power of attorney. not a complicated document to put in place. The alternative, if you don't, is a very complicated, very expensive court application where your children, your family, your partner, that's your husband or wife, would have to go to court to get a judge's permission for them to manage your financial affairs. So something you should definitely consider. And then there are different types of powers of attorney. You can have powers of attorney to deal with your property, your land, powers of attorney to deal with what happens if you had Alzheimer's or you were in a coma, a power of attorney also to deal with your healthcare. And that's the next document I'd like to speak about. So whether it's a power of attorney to deal with your health or a representation agreement, as it's called in British Columbia, or a living will, as it's called in Ontario, you should also consider putting in place a document that says who will look after you in the event that you're hospitalized. And for example, you don't have children, or you don't have a husband or a wife who's living. Who makes the decision? Who's the next of kin? And it makes sense to put that in place because we are all living to be much older these days. And so there may come a time where it might not be our partner who needs to make decisions for us, those end of life type decisions. And the other thing, unfortunately, is some of us are having illnesses during our life and may need assistance of a family member. And so if we don't have an immediate family member, who assists us? Is it a cousin? Is it a distant uncle? Who can step in and speak to our doctors, our nurses, and give guidance? If there isn't paperwork in place, it's very difficult. So with that, just before we go to questions, I think I'm just going to stop this here for a moment. Did we have any other presenters before we take questions?
Is Nabil here? Imam, Nabil, by any chance?
Maybe, you may have to unmute everybody if he signed in.
Or no, he should.
Oh, there, yay!
Yay. Okay, so I'm going to introduce Imam Nabil, and Nabil, you can start now.
Assalamu alaikum wa rahmatullah. Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Wa salatu wa salamu ala Rasulil Kareem wa ala alihi wa ashabihi ajma'in. Amma ba'd. Assalamu alaikum. Hopefully everybody's doing well. I would like to show my gratitude and appreciation to all the panelists and attendees. MashaAllah, it's a very important topic here. The Prophet sallallahu alaihi wasallam said that Allimu al-fara'id. He said, teach people inheritance. Because he said, out of all the knowledges that exist, the first knowledge that will be taken away from this world is the knowledge of inheritance. And that is in two aspects. One is the application, and the second is the teachings of it. So this is this type of seminar is actually a very blessed thing when you look at it from an Islamic perspective. Because the Prophet ﷺ, he said that whoever revives a teaching of Islam or a sunnah in Islam that was once alive but died, then they will have the reward of a martyr. In one hadith it says that they will have the reward of 100 martyrs. So this this seminar, this wills and inheritance seminar is reviving sunnah, is reviving Islam. And amidst these this time and this era that we live in, where Islam is kind of alienated to society, and rather Islam is put always on the defense. As Brother Ibrahim mentioned, Islam truly put everything else on the defense. When it came into society where they did not give rights to women, and they did not give rights to animals, they did not give rights to many people, especially the weak and the poor and all of those in between. Islam combated the society and provided rules that if you live in the society, you must follow. And this is why inheritance is actually one of the most unique discussions of all of the discussions of fiqh. Why is that? Is because it is the sole discussion that is almost unanimously agreed upon. It is the sole discussion in its entirety that almost every single aspect of it, you could say 90%, 95%, is agreed upon amongst all of the scholars of Ahlul Sunnah wal Jama'ah. Because Allah subhanahu wa ta'ala took his time out, and Allah subhanahu wa ta'ala expressed extensively in Surah An-Nisa, where Allah spoke about every single situation. This is called the knowledge of the Dhul Arham, or the Ansab, the different portions that exist, that definitely Brother Ibrahim and the other panelists had mentioned. Now, because you guys heard a lot of beautiful things, I just want people to understand the importance of learning this stuff. Learning it not only from an educational, religious side, for the sake of our spirit, but for the sake of our actual accountability. When a person thinks about it, everybody has this hope to die and say, Ashhadu an la ilaha illallah wa ashhadu anna Muhammadan Rasulullah. Everyone. Every Muslim hopes that the last word they say is kalima, right? And that we know that man kana akhir kalamihi la ilaha dakhal jannah. Whoever says la ilaha illallah as his last words, he is destined for paradise. But wealth,
I think we lost Imam Nabil there for a second.
into Islam and Sunnah and Quran, this is something that is unfortunately forgotten. And once something like this is forgotten, you can only imagine that people die with their last deeds being against them. And there are rules of munasakha that if a person takes the wrong inheritance, imagine if a father, can you guys all hear me? Because it says unstable. Okay. Imagine if a father distributes his wealth against Sharia compliance, against the compliance of wills in Islam. And instead he gives how he desires. The children that take that wealth have taken the rights of others. And if that wealth goes into their family and they die with that wealth, becomes generation wealth, and it goes to the next people, they have taken the wrong wealth, the invalid wealth, the impure wealth of their forefathers. And like this, there are rules of munasakha, that Islam actually goes back generations to put everything back in order when mistakes are made. So to not make these mistakes, we need to be well informed. And to be content, to be satisfied with our last moments in our life, we need to take real concern about things like this. And you have, mashallah, Muslim people that are well-versed, legally capable, empowered by the state in Canada, that are providing you free webinars like this. And they are there for you when you want to take that next step and discuss and consult with them. And there is no lack of sources, is a lack of encouragement that exists in the people. So the passion that exists in Sister Iqra and Sister Mina and Ibrahim and everybody here is beautiful. But that passion needs to result into and formulate into actual action by the people. So remember, if you want to have a good ending in your life, your wealth is a part of that. And don't forget this. Prophet ﷺ, like I said, and I'll mention it again, that teach people inheritance, because the first knowledge that will be removed from this world is the knowledge of inheritance. Just like this, we need to live, we need to learn, we need to spread this knowledge and this importance. And you have all the people here that are available, Canada, across the country, and use this to your means. Assalamu alaikum wa rahmatullah.
Jazakallahu khairan for being involved in this wills webinar. We are now, and thank you so much, Nabil, for providing the Islamic perspective regarding wills. Now we're going to have some questions. So the first question will be addressed to Nabil. And the question, Nabil, is, are there key differences in Islamic inheritance between Sunnis and Shias? And you're on mute, by the way, so unmute.
There are some differences in terms of the ahadith. In terms of some of the hadith that are used, there are some discussions, like la wasiyata li warith, and some of the rules of wasiyah, like the hadith of Sa'ad bin Abi Waqqas and tathlith being 1/3, etc. Some of the Shias, and there are many groups of Shias, right? You have the Ithna Ashariya, the Zaydiyya, and Imamiyya, and all, so many groups. Just like in the Ahlul Sunnah, you have the Shafi'is and Malikis. But in the Hanafi, in the Ahlul Sunnah side, there are not much debates. Only in very, very, you could say, very secluded situations. And majority of Shias do agree with the Sunnis, because everybody is taking directly from Quran. And because Quran has mentioned all of the kalala, and these situations of daughters and children and parents and etc. explicitly, so majority of inheritance is an overall agreed upon consensus, which a person doesn't have to be worried about it. Okay?
Thank you.
I'll address this next question to Azool. So when one spouse dies, how does the principal residence get distributed? Would the surviving spouse have to sell property, or would the inheritors have to wait until the spouse also dies? The other spouse also dies. And you're on mute, Azool.
Thank you. If the couple own the property together, once one spouse passes, it's paperwork that's completed and the property can pass to the surviving spouse. If the property is owned by the spouse who has passed away, then the property would go to those named in that person's will. And if they don't have a will, would pass according to laws set up by the government of the province that the person lives in, which would determine how the property passes. And so, as Ibrahim addressed in his presentation, if you want to ensure that your spouse will receive the house, then one of the things to do is to ensure that your spouse's name is on title when you're alive. And it's not a complicated process, because the alternate is, if you wanted your spouse to receive the property, your spouse in British Columbia would have to pay 1.4% of the value of your home, and in Ontario, 1.5%. And so a lot of money, just because somebody hadn't taken an hour or 2 hours to put in place the correct paperwork.
Thank you so much, Azool. The next question is to either Azool or Ibrahim. Can you please talk about trust that can be set up for young adults and how that can be set up?
Maybe I'll go ahead, Azool.
Please.
And sorry, I forgot to mention this in the presentation. So one of the most important things we do, lawyers like Azool and myself, is we try to make sure that young children are protected. And that's in addition to the guardian appointments, as Azool mentioned, who will be the trustees of the assets for your minor children, so children under the age of 19 and varies by the province. But even more than that is young adults. So let's say you have $1 million estate and you pass away and your 18-year-old son gets $1 million. So he might not invest it into his education. Maybe he'll buy a sports car. So we absolutely create trusts, testamentary trusts, they're called, because they're done through the will. And as Azool actually mentioned it in the first part of the presentation, you can, what we normally do, for example, and I'll let Azool add whatever, we say, you know, a normal case is we give 1/3. So let's say that both parents pass away and there's a number of kids. The number of children will, the assets will in the will go into a testamentary trust managed by the executors or the estate trustees, and they will have to spend, based on the terms of the trust, on the children. Now, the children won't control those assets until whatever age you specify. Now, remember, they still benefit from that trust. They're beneficiaries of that trust. Other people are trustees who are fiduciaries and have to manage as a prudent parent would manage that money. But we want to transition this to the children. So, for example, at age 23, we might give 1/3 of the remaining assets to the adult child and make him or her a co-trustee with the other trustees, with the other trustee. And then maybe 2 years later at age 25, for example, we'll give all the wealth remaining to that child, his or her share, in fully vested in them, fully controlled by them. So we absolutely do, for almost all wills, is we have a trust for the children, for young adult children, and maybe for disabled beneficiaries. I didn't mention this, but if you have a child who's receiving ODSP benefit, disability pension benefit from the Ontario government, that's similar in many provinces, they lose this benefit if they get assets directly over a certain minimum threshold. And so we have to do a Henson trust, which is a fully discretionary trust, which means they don't get, it's a special type of trust basically, and they don't have control of that ever, but that way they continue to get the disability benefits. Hopefully that's answered the question, but Azool, please add anything that you'd like.
You answered it well.
Okay, I would just like to say on the Sunni Shia thing, and I just want to thank Imam Nabil for his really passionate and amazing presentation. From a practitioner perspective, the main practical difference that I've just discovered through practice, and I'm not an expert on the Jafri school, is that in Sunni law, you need a son to block siblings. But for the Shia, from what I understand, a daughter can block the siblings. So in our context, in a Western context, it actually makes it easier because we don't have to worry about siblings inheriting prematurely, we could say. So that's just one practical difference. But as Sheikh Nabil said, there is almost uniform consensus on inheritance law generally compared to other aspects within Islamic law.
Thank you, Ibrahim. I see some common themes between some of the questions. So I'm gonna just ask a general question. What should I do about my overseas assets? And should I have different wills for my assets in Canada versus my assets overseas?
Will, would you like to start?
Sure. So many people, I think the first question is, what is it that you have overseas and what is the value? So if it's not of a very great value, then it may be just as easy just to deal with it in your Canadian will. But if there's greater value, then it often makes sense to have a separate will, because then that will can be used in that country, and your Canadian will can deal with your Canadian assets. It's often much more efficient, and it can often, in fact, be cheaper. And so the question really is, first, that's the type of a question which you would take to a local lawyer and a lawyer in the place where you have those other assets, and then you can make the best decision, because it's very specific to exactly what type of asset you hold. Is it property? Is it investments? And then it also depends which country.
I would just add quickly to that, totally agree with whether Brother Azool said. This reminds me that, remember in the beginning, I talked about the jurisdiction issues. So will law is provincial, and probate tax, from my understanding in Alberta, for example, is like a flat $400 or something. So you don't need to do all the elaborate probate planning that you need to do in Ontario. So if you have assets, let's say you live in Alberta, you live in Alberta, but you have assets in Ontario or vice versa, you may need a will for certain assets in both provinces. Now, let alone foreign jurisdictions, you might have mandatory distributions in Europe or in Muslim personal law jurisdictions, including India. So you really need to talk to a local lawyer if the assets are significant, like Azool said.
All right, this can be either addressed to Azool or Ibrahim. Should a person just get, what's the difference between a will that's made by a lawyer or a notarized will, and then compared to a will like you get a kit from Staples?
So a will need not be notarized. If you had it notarized, what that means is a notary perhaps, and both Ibrahim and I can do that, has just seen you sign it, but there's no advice. Think in terms of a wills kit, the best way to explain it is if you go to the Bay and you buy a clothing item, it might fit you well, but it could be loose in the shoulders if it's a suit. It could be loose in the waist if it's pants, or the pants could be too long. So yeah, it might work, but it also might not work. And so you'll have to decide. We're not going to tell you that you should see a lawyer or get a kit. I think the most important thing that we would both agree on is you should have a will. We'll start there. And then depending on how much you want to customize it, and depending on your family situation and the way you own your assets, then you should be considering whether it makes sense to trust a kit, something that one size fits all versus something that's specific to your situation. Just like you probably don't use a kit to deal with your RRSPs, you probably shouldn't do this with your will. And I'd seen another question, and so I'm going to just touch on this, come through a little while ago. How often do I update my will? What I tell people is it's on a major change in your family situation. So if as a young person you own property, you bought that first condo, whether it's in Yaletown or in the beaches in Toronto, you're going to want a will. So it says what happens to that property of yours. After you get married, you would want to look after your spouse. After you have children, and then perhaps as your children become adults, or you have grandchildren. If you haven't done a will yet and you already have grandchildren, you're probably not going to have to do another will. Now would be the time to do it. So it's when there's a major change in your life, many people will do one will and it will be sufficient for their entire life.
As Azool said, I'd say a good rule of thumb is, so everybody should have a will, whether you need a lawyer or not. I would say what I found in my experience, say if you have minor children, you probably should get a lawyer to do the will. If you have assets more than 50,000, you probably should get a lawyer to get a will to do the will. So basically, if you have no assets, no significant assets, no kids, you may be able to escape without getting a lawyer to do a will. But it's like basically doing the braces yourself or getting an orthodontist to do your braces. It all depends. You know, if it's very straightforward, you may be able to do it yourself. But the problem is you don't know. A lot of people say, oh, I have a simple will. And then we go into like, you know, they were divorced before, there's assets. That's another life. You know, if you get divorced, you get married, a kid passes away, a kid gets a disability. Unfortunately, you may have to, those are update reasons for a will. So if you're kind of like middle class, you know, that phrase I hate, that's very political. You probably need a will from a lawyer.
Thank you. And we'll finish off with just two final questions. So one of the ones that came in was, how long does it take to complete the wills process when it starts? And another theme I saw in the questions was, where can someone go if they cannot afford to hire a lawyer to draft their wills?
Azool, go ahead.
Sure. So in British Columbia, there are some wills clinics. And so if you were to look me up and phone me, I'm a lawyer in Vancouver, I'd be happy to give you the name, but there is a wills clinic that takes place one day a week. It's run by an agency called Access Pro Bono. It's for people of limited means. They will assist you in preparing a will. And what was the second part of that? I just want to make sure I get that right, Ikra.
It was once you start the process of drafting your will, how long does it usually take to complete?
So, often it'll be less than a month. I think the delay sometimes, or where it will take long, and it can be done even in a week or two, just depending on how busy the lawyer you approach is sometimes you'll have an initial conversation with the lawyer and they'll give you some homework, or they'll make you think of some things that you hadn't thought about. And so you'll have to go away and reflect, take a week or two to reflect, give your instructions back to the lawyer, after which they can prepare the documents, and then you go in to sign. But not very long, a couple weeks generally.
I just put into the chat the links for the Access Pro Bono in BC, and also for Ontario, for Toronto. These are free PBSC. So these are the links you can click if you can't afford to have a lawyer. You'll see the links in the group chat.
Maybe I'll just mention on the cost generally. So like, because I saw the questions in the chat, a basic will at least maybe like under $400, and the power of attorney maybe $100 more. It can go up to thousands if you have complicated corporate assets and so forth. But I think it's probably a good investment for a few $100 because you save. Like if you don't do a will, it's much more hassle for your beneficiaries to get the assets later. So it's basically pay now or pay more later. But it's everybody's choice. There's no shortage of business, alhamdulillah, but it's time consuming to get the original information. So to make the process more quick, know who your guardians are going to be, who your executors are going to be, and have a good organization of your assets, and that will assist the lawyer a lot.
Minna, you're on mute.
All right, I just want to let everyone know that we appreciate that you attended the webinar, and where we hope it was helpful for you. And if you have any more questions, you can contact the CMLA and we'll be happy to assist you. I will send the email address in the group chat as well, so you can email us. And also we are creating a Muslim legal clinic in Ontario. So it'll provide people who can't afford to have a lawyer to go to use the Muslim legal clinic. If you are interested in donating for this Muslim legal clinic, the link is in the the chat group here, and just I'm hoping you can click it. But just if you go to Launch Good campaign, you'll see about the free clinic. And thank you so much for everything, and we appreciate your time. I'll just put the CMLA email for you guys as well, so you can save it, or just remember, it's just contactcmla@gmail.com. If you have any questions, if it's related to BC, it'll be directed to me, and if it's in Ontario, it'll be directed to someone else, and they will be able to help you. We can connect you with one of our lawyers here or someone else to give you more information, because I know we couldn't answer all of the questions. There's just so many, so we can set up something so that maybe we can assist you further. Thank you.
Jazakallah khair, everyone. Jazakallah khair to our
Thank you
speakers
so much
as well.
for the invitation. Thank you to all the hard work for the organizers.
And thank you to the speakers as well.
Thank you. Assalamu alaikum.
Wa alaikum assalam. Have a good day. Sorry for the technical difficulties and going over time, but thanks for the
Assalamu alaikum,
patience.
everyone.
Assalamu alaikum wa rahmatullah.